Thanks very much for being with us, Richard. And here in the studio, David Webb, host of the David Webb Show on Sirius XM Radio, co-founder of Tea Party 365. All right, gentlemen, Richard, let me start with you because David Prosser said before the election, as all of these unions and public workers and some liberal groups were coming in and throwing their weight behind his challenger, he said, you know what, if I go down in defeat, and I'm paraphrasing here, he said, this is the end of judicial independence. Does he have a point?
Not at all. I think the judges are subjected to the people, especially in Wisconsin. It is a voter, it's an electoral issue, and if the people feel as though he doesn't represent their interest, then they have the right to vote him out. He's already served one 10-year term as a Supreme Court justice, and if he doesn't win a second term, then the people have spoken.
David?
Well, actually, the key in that is subject to the people. When you've got outside interest money involved in this, when you've got a heavy union push and it's such a heavy partisan push, it's not just the people of Wisconsin involved, it's union interests. And let's face it, Richard Trumka, Andy Stern, and all these other union supporters, including this administration, are in there to win this battle to keep collective bargaining.
I want to move on to the underlying issue in this, Richard, and that is Judge Marianne Sumi, the circuit court judge, who issued this temporary restraining order saying that the legislature, the Republicans, violated the open meetings law, may have violated the open meetings law without giving proper notice and so on and so forth. And she issued a temporary restraining order. There are two Wisconsin Supreme Court cases, and we had our brain room look them up over the weekend. Both of them stand for the following proposition: that a judge has no business getting involved in legislative matters absent a constitutional issue, and there is none here. So isn't Judge Sumi just wrong in issuing this TRO?
Not at all, Greg. What Judge Toomey is saying, what the judge is saying is pretty simple. What the judge is saying is that they violated the due process of members of the House of Representatives and the public. The people that are elected and the people that are elected to serve in public office in Wisconsin have to notify their constituents and their voters of when they're having a meeting.
Unless it's a special session, in which case there are no such rules that apply to the open meeting law. And the parliamentarian, this is a guy who lives and breathes the rules. He's the chief clerk. He issued a statement immediately after all of this occurred, and he said, in essence, this is a special session. There is no open meeting law. We gave notice on the bulletin board of a couple of hours, and that was more than we had to. So there's been no violation of open meeting rules.
Well, like I said, it's pretty simple. This is about the voters of Madison, Wisconsin, and the voters of Wisconsin in general. At the end of the day, these individuals want to know about what is happening in their state house, and I think they should have at least a grace period of 24 hours to know what's being up for consideration, so they have full and complete transparency.
David?
The GOP complains.
No. You're contradicting yourself, because here's what you're saying. It is, with all due respect, it's about the rule of law. And you just talked about the fact that laws need to be followed. Well, the judge, one, cannot rule on that issue because it is outside her purview. They judge shop this to try and keep the battle going. And what you just made about the people of Wisconsin, the parliamentarian and the law and the system in place says that they abide the law in this case. They didn't have to follow that 2-day notice.
Well, the other issue is this. The issue is not judicially ripe until the law takes effect, and the judge prevented it from taking effect, so she's premature.
Right. Again, she has no right within her purview. First of all, at a circuit court judge level, think about this. This should have gone, if at anything, to an appellate or Supreme Court after the law is taken effect. But she cannot preemptively strike against a law which hasn't taken effect.
You know, Richard, it is true. They shopped this around. They filed a bunch of lawsuits in a bunch of different courts, and all of those judges said, what are you, nuts? Until they finally found one who bit, and that was Marianne Sumi.
Look, it's pretty simple. When